Welcome back to Organized, the business law breakdown. I'm your host, Seth C. Orenberg. Today we're going to explore one of the most fundamental principles in contract law, mutual assent, and how bargains are formed. Have you ever been in a conversation where you thought someone was joking, but they were dead serious? Imagine you're at a party and someone says, "I'll sell you my Porsche for $500. You laugh it off, but later they show up with the keys. Did you just agree to a contract? Well, according to the objective theory of contract, what matters is what's communicated outwardly, not what's happening in your head. Last time we talked about capacity, who can legally make a contract and what happens when a person lacks the ability to understand the deal they're entering into. Now we're shifting our focus to the agreement itself. What makes a bargain legally binding? Today, we'll dive deep into bargains, the objective theory of contract, and how contracts are formed based on an outward manifestation of assent. We'll break down a classic case, Lucy versus Zehmer, to show how courts interpret agreements based on what people say and do rather than what they secretly think. Stick with me as we break down this fundamental concept of contract law, and be sure to share your thoughts and questions in the comments after this episode. In contract law, what matters most is mutual assent, the idea that both parties need to agree to the terms of the contract for it to be legally binding, and that court should enforce the agreement that the parties wanted. But how does the law determine whether there's actually been an agreement and what it actually contains? That's where the objective theory of contract law comes in. The objective theory says it doesn't matter what you're thinking in your head. What matters is what you outwardly show or manifest to the other person. If you act in a way that would make a reasonable person believe you're agreeing to a contract, then that's what the law will recognize as assent. It's an outward focused analysis, which means the courts don't care what your secret intentions are. They only care what you said and did. One of the best known cases that illustrates this concept is Lucy versus Zehmer. In that case, Lucy tried to buy Zehmer's farm, and the two discussed it at length over drinks. Zehmer later claimed he was joking. He didn't actually intend to sell the farm, but because he had written out a contract and signed it, the court held a reasonable person in Lucy's position would have believed Zehmer was serious about the deal. The key point here is that the law looks at how a reasonable person would interpret a situation. If someone makes an offer and you accept it, the law presumes you meant what you said, unless you have evidence to show otherwise. And that evidence may or may not be admitted in court. We'll talk about that later when we talk about the parole evidence rule. This helps create clarity and certainty in contracts. It prevents people from backing out of agreements based on secret internal thoughts. Bargains form the backbone of most contracts. Whether you're buying a car, making an employment agreement, or just making a deal with a friend, the law wants to see evidence of mutual assent, both parties agreeing to the same terms. So the next time you think you've entered into a casual conversation that turns serious, remember that what you say can legally bind you to a contract. Now let's break it down. One of the most famous examples that illustrates the objective theory of contract is Lucy versus Zehmer. This case took place in Virginia in the 1950s and involves two men, Lucy and Zehmer, who were sitting at a bar one night. After a few drinks, Lucy decided to ask Zehmer to sell his farm. They ended up having a long conversation about it, and Zehmer wrote down the terms of sale on the back of a restaurant check. He even got his wife to sign it. But here's the twist. Zehmer later claimed he was joking, and he didn't actually intend to sell his farm. Lucy, on the other hand, took the written contract seriously and went to court to enforce the deal. The court had to decide whether Zehmer's outward actions, writing down the contract and signing it, showed mutual assent, even if he claimed he was joking. The court applied the objective theory of contract, which means they didn't focus on what Zehmer says he secretly thought. Instead, they looked at how his actions appeared to a reasonable person in Lucy's shoes. Zehmer wrote out the terms of the contract, discussed the deal seriously, and signed it. leading the court to decide a reasonable person in Lucy's position believed the contract was real. This conclusion was aided by the eyewitness testimony of a waitress who watched this unfold, and she played the role of a sort of reasonable person who was in the room and observed objectively what happened and believed that it appeared that a serious deal was unfolding. The key takeaway from this case is that what you outwardly show matters more than what you're internally thinking, at least in contract law. Other areas of law care much more about intentions, but contract law cares about your outward manifestations and how they would be reasonably perceived by a person. Zehmer's claim that he was joking didn't hold up. His actions, writing out the contract and signing it, gave the reasonable impression that he was serious. The law requires outward manifestations of mutual assent to form a contract, and Zehmer's actions met that requirement. The case also emphasizes the importance of being clear in your communication when discussing deals. Even if you think you're joking, the other party might take you seriously, and the law will take you at your word. Now, let's play a quick what if. Imagine two people agree to buy and sell goods that will be shipped on a vessel named the Peerless. They shake hands on the deal and think they've come to an agreement to ship goods on the Peerless. But here's the catch. There are actually two different ships, both named the Peerless, and the buyer and the seller are each thinking of a different ship. So when it comes time to deliver the goods, the seller expects them to be shipped on one Peerless, and the buyer expects them to be shipped on the other Peerless. What happens when there's no objective truth? This hypothetical is based on the real case of Raffles v. Wickelhaus, and it presents a unique problem for contract law. In this case, there's no clear objective truth about which ship the Peerless refers to. Each party had a valid but different understanding of the contract's terms. And there was no waitress or neutral third-party observer who could settle the dispute. The law typically applies the objective theory of contract, meaning it looks at what a reasonable person would think the agreement was. But in this case, there's no objective answer. Both interpretations are equally reasonable, and neither party has any reason to think that it's wrong. In situations like this, when the words could reasonably mean two different things and there's no objective way to determine what was reasonably meant, the court found there was no mutual assent. There was no quote unquote meeting of the minds. Since both parties had different understandings of the key terms, there was no contract. This case teaches us that contracts can only be formed when parties agree on the same thing. When the words can be interpreted in multiple ways with no clear answer, there's no enforceable agreement. Let's break it down with another real-world example that led to the collapse of a mutual agreement. In the case of Hill-Schaefer Partnership versus Chilson Family Trust, the parties were negotiating the sale of land that was made up of multiple parcels. The buyers, Hill and Schaefer, thought they were purchasing Butler North and a triangular parcel of land. But the seller mistakenly believed they were selling Butler North and Butler South. The misunderstanding came to light after the contract was signed, leading to dispute over which parcel was actually part of the sale. The issue here isn't just that the parties had different interpretations of the contract. It's that both interpretations were reasonable because the contract was worded ambiguously. This brings up the concept often referred to as the meeting of the minds. The phrase meeting of the minds is often stated and more oftenly misunderstood. Many people think that for a contract to be valid, both parties need to subjectively agree on all the terms. That is what the phrase meeting of the minds implies, that both parties actually thought the same thing. But that's not the law. Contracts don't require parties to actually think the same thing. They only require that parties manifest the same thing through their outward actions. As Professor Wilson said in his treatise on contract law, in the formation of contracts, it was long ago settled that the secret intent was immaterial, only overt acts being considered in the determination of such mutual assent as that branch of law requires. What he means is that what parties actually think is irrelevant. What matters is how they present their agreement to the outside world, what they manifest. So the law does not require a meeting of the minds in the subjective sense. Rather, an agreement on the surface, based on what has been articulated, this is what the courts will require. In the triangle problem, the material terms of the contract, specifically what parcels of land were being sold, was ambiguous. Both parties had different but equally valid interpretations of the contract. The reason the contract failed wasn't because there was no subjective meeting of the minds. It failed because the objective words were unclear, so the court could not resolve which of the two definitions was reasonable. And the parties also failed to have a subjective meeting of the minds. So going one level deeper, there was no mutual assent, either objectively or subjectively. This is similar to the Raffles v. Wickelhaus case, where the ambiguous term peerless referred to two different ships, and the court found no contract existed because there is no mutual understanding of a material term. Again, in both cases, the key takeaway is that while courts use the objective theory of contracts, meaning they care primarily about what's expressed, not what's internally thought. If the outward expression is ambiguous or open to multiple interpretations, there may be no mutual assent. The courts can then take testimony to see if the parties had an actual agreement subjectively, but the law does not require, as an element, a subjective meeting of the minds. It requires clarity in the outward expression of agreement. Let's look at a pop culture example of mutual assent from the show Friends. In one episode, Chandler casually offers to let Ross move in with him. They're having a friendly conversation, and Ross thinks Chandler is joking, but Chandler is actually serious. This communication leads to an awkward moment when Ross later realized Chandler really expected him to move in. This situation mirrors what we've been talking about with the objective theory of contract. Ross didn't take the offer seriously, but Chandler's outward actions made it seem like he did. While this wasn't a formal contract, it's a great illustration of how outward manifestation can create real expectations, even when parties aren't aware of the seriousness of the offer. Let's quickly recap what we covered today. We started by exploring the idea of mutual assent and how contracts are formed based on outward displays of agreement. According to the objective theory of contract, the law looks at what you say and do, not what you're thinking internally. We then broke down the case of Lucy versus Zehmer, where a written contract for the sale of a farm was enforced because the parties' actions showed an agreement, even though one party later claimed it was a joke. The key takeaway is outward manifestations. The key takeaway there is that outward manifestations matter, not hidden intentions. In our What If segment, we explore the problem of ambiguity, looking at the Raffles versus Wickelhaus case. When two parties have equally valid but different interpretations of a contract term, and when that contract term has no objective reasonable meaning, there is probably no mutual assent, so the contract can't be enforced. This teaches us that clear communication is essential for forming a binding contract. In our second Break It Down, we explored a common misunderstanding about the term meeting of the minds. Contrary to popular belief, contracts don't require parties to subjectively agree on the same thing. They just need to express the same thing. As in the case of the triangle problem, the ambiguity in the material terms led to no objective mutual assent, and then the court inquired whether there was subjective mutual assent. Finding both failed, there was no agreement in that case, nor was there agreement in the Raffles versus Wickelhaus case either. Finally, we looked at a Friends example, where a casual conversation led to a misunderstanding about moving in together. The pop culture moment illustrates how important it is to be clear in your communications to avoid accidentally creating agreements. Before we wrap up, take a moment to think about the last time you made a casual agreement or had a conversation that turned into a deal. Have you ever had a chat with a friend that they later held you to some expectations of performance? Did your actions match your intentions? Or did someone misunderstand what you meant? Contracts can form when you least expect it, based on what you say and do. If you have questions about today's episode or want to share your own what if scenarios, I'd love to hear from you. Don't forget to subscribe, leave a review, and share this podcast with anyone who's navigating contracts, law, and business. Next time, we'll dive into the world of offers. What makes an offer binding? How can it be revoked? So stay tuned for another deep dive into contract law. That's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Orenberg, and I appreciate you joining me to explore how contracts are formed based on outward manifestations. Remember, until next time, keep your agreement strong and your argument stronger.